Next is plea negotiations. Most findings of guilt do not result from a verdict trial. They actually come from plea deals or plea negotiations. About 90% of all felony convictions are products from plea negotiations between the prosecutor and the defense attorney. Judges are sometimes involved as well, but they mostly just either accept or reject the plea deal. The public thinks that plea bargaining is a lenient sentence, but there is an informal understanding of what a case is worth within the court system. Plea bargaining is governed by this informal understanding of what sentence is appropriate for the defendant. Next is the trial. So if a case makes it to trial, then the defendant does have the right to a trial by jury, and this is one of the most fundamental rights granted to those accused of violating criminal law. The defendant can either be tried by a judge sitting alone, which is called a bench trial, or by a jury. A jury trial begins with selecting 12 jurors. And this is voir dire. Each side gets a certain number of challenges, so they can have a challenge for cause or a challenge without cause. Challenge without cause means they can just get rid of anybody on the jury that they don't like, and they don't have to give a reason for it. Prosecutors and defense attorneys have a limited number of these that is often set by the judge before voir dire starts. Or they have a challenge for cause. This means that they can get rid of a potential juror as long as they give a valid reason. So if someone knows the defendant, obviously they're going to challenge for cause them and get them off of the jury because they might be biased. After voir dire and the jurors are picked, each side makes their opening statements. An opening statement is just indicating what they think the evidence in the case will show. After opening statements, the prosecutor calls the first witness. And the reason they get to call the first witness is because they have the burden of proving the defendant is guilty beyond a reasonable doubt. After the prosecutor goes through their witnesses and the defense has their chance to cross-examine, then the defense gets to call their witnesses. So, after all of the evidence has been introduced, each side gets to make their closing statements to the jury. The judge then instructs the jury about the law, and the jurors retire then to deliberate. Procedures for this part of the trial are set by the state, and statistically, the defendant's chances for acquittal is not good. Next is sentencing. So 90% of cases, criminal trials, end with convictions. Once guilt has been established by either a plea deal or conviction at trial, The members of the courtroom work as a group to help the judge determine what sentence to impose. Despite the fact that 90% of cases of criminal trials end in convictions, most defendants are not really concerned with that. What they are concerned with is how many years they get. This kind of explains why most defendants get a plea deal, so they plead guilty for a specific sentence that they want or that they accept, essentially. So then the probation officers usually play a significant role in the sentencing portion of a felony prosecution. And the reason this is because they do a pre-sentence investigation. A pre-sentence investigation is just where the probation officers really look into the defendant's life. So this would be educational background, their family ties, their friends, their financial situation, stuff like that. And then they present a sentencing recommendation. Sentencing, the main decision the judge needs to make with sentencing is whether to impose a prison sentence or place the defendant on probation. Fines are rarely used in felony cases, and this is because generally, if you are being tried with a felony, it is a year or more in jail or prison, while a misdemeanor is less than a year and can include fines and community service and things like that. The death penalty is largely debated, but in actuality is limited to only some first-degree murder cases. So just because there is a defendant being charged with first-degree murder, this does not mean that they will automatically get the death penalty, or that the death penalty is going to be a factor in deciding, because only some first-degree murder cases actually have that option. Prison overcrowding is the dominant reality of sentencing, and because of this, it's almost like a tool of the judges has been taken away. And recently, attention has began to focus on the fact that the political rhetoric of lock them up and throw away the key kind of led to prison overcrowding. And this has caused policymakers to come up with different sanctions that provide alternatives to incarceration. Next is the appeal. Mostly all defendants found guilty during trials contest their fate. They file an appeal with a higher court in the hope that they will receive a new trial. Most defendants in their appeal process are unsuccessful, despite what the public may believe. Fewer than 1 in 10 appellants actually achieve victory in getting a new trial, and those who do are reconvicted in that different trial. And defendants who plead guilty rarely appeal. The appellate court opinions do affect future cases. The courts decide policy matters that shape the operation of the entire criminal justice system. So like I said before, the appellate courts do not have a new trial right away. They do not have jurors. They do not call witnesses or question witnesses. All that happens during the appeal is arguing about whether the lower court did the procedure correctly. And if the appellate court decides they did do the procedure correctly, then a new trial is ordered. However, like I did say, most appellants do not get a new trial. Next, I'm going to define the law. So generally, the law can be summarized into 2 words, which are human conflict. And human conflict can be a variety of different things. It can be a controversy over how much money is owed, a quarrel between husband and wife, or husband kids, wife kids, or even just between the kids. It can be a collision at an intersection, or it can be the theft of a television set. And these are just a few examples. Everyday activities do depend on mechanisms for mediating inevitable human conflicts. Without these mechanisms, individual parties might seek private, more violent means of retribution, and this would be vigilantism, which is just not a good idea. So the law is an everyday word. Many parents will say, my word is law, but it is, or just we have a law in our country. But most scholars define law as a body of rules enacted by public officials in a legitimate manner and backed by the force of the state. This definition can be broken into 4 phases, and each phase has important implications for how we think about the law. The first element is that law is a body of rules and is self-evident. It is not immediately obvious, but the fact that these rules and regulations are found in a variety of sources, such as statutes, constitutions, court decisions, and administrative regulations, proves that it's just a body of rules that can be separate. The second element is that law is enacted by public officials and is of critical importance. All organizations of any size or complexity have rules and regulations that govern their members. These private rules are not the law, and they are not recognized by public officials. An example of public officials would be judges, legislators, and administrative officials. The third element is that law is enacted in a legitimate manner and means that it must be agreed upon ahead of time how the rules will be